My name is Anisha and I am an intern at LEXIS and Company. Today in this video, I'll be discussing with you all the concept of attempt in IPC, and I will also be discussing about the essentials, scope and the difference between preparation and attempt. So let's proceed. Now if we talk about attempt, then if a person commits a crime voluntarily or after preparation, the doing of it involves a total 4 stages, and in every crime there is first intention to commit it, and secondly the preparation to commit it, and the third one is the attempt to commit it, and fourthly it is the accomplishment. So among all this concept, we can understand that attempt, it is the third stage, but it is very hard to understand and that what attempt is, and it is noted as for its intricacies, like the accomplishment or the commission of the offense. It totally depends on the success of the third stage, that is the attempt. To reach this stage 4, the attempt has to be succeeded, and if it fails due to reasons beyond control, it is said to constitute an attempt to commit the offense. Now section 511 in IPC, it talks about the punishment for attempting to commit offenses, and it is also punishable with imprisonment for life or other imprisonment. This section 511, it reads as, let me tell you, it says that whoever attempts to commit an offense punishable by this code with imprisonment for life or imprisonment, or to cause such an offense to be committed, and in such attempt does any act towards the commission of the offense, shall, where no express provision has been applied or made in the code for the punishment of such attempt, shall be punished with imprisonment of any description provided for the offense for a term which may extend to 1/2 of the imprisonment for life, or as the case may be 1/2 of the longest term of the imprisonment provided for that offense, or with also fine as is provided for that offense, or with both. Now if we talk about what are the essentials of attempt, then there are total 3 essentials. The first one is guilty intention to commit an offense. Second one is such act should be done towards committing the offense, and the third one is act must also fall short of committing the offense. So this was all about the essentials of attempt. Now if we move towards the nature, meaning and the scope of attempt, then we can say that though attempt is nowhere defined in IPC, but we can understand that attempt is also described into 3 types on the basis of the kind of treatment as is provided in IPC. Like firstly, there are attempts that are treated at par with the actual offense and entail the same sanction as the attempted offense. Like for example, section 121, section 124, section 124A, and section 125, section 126 and section 131, etc. And there are offenses like sedition, waging and attempting to wage war against the government of India using evidences to be false, etc. So secondly, such attempts that are kept on on special footing and are treated in terms of special provisions, and these include the offenses like attempt to murder, attempt to commit culpable homicide, attempt to commit suicide, and so on. The offenses themselves, they are provided separate punishment, and for example section 302, which provides for the punishment for the murder, and thirdly, there are such attempts that are not covered by the first 2 categories that I just mentioned, and they are just subject to the general omnibus that provides the definition and the sanctions for the attempt under the diverse situation. This is provided under section 511 of the IPC, and in one of the case in Malkiyat Singh versus the state of Punjab, the appellant Malkiyat Singh, he was a truck driver and he was carrying paddy out of the jurisdiction of the state of Punjab without a license in the violation of Punjab Control Order 1959. And he was stopped and that is his truck 14 miles away from the Punjab Delhi border, and he was also prosecuted for an attempt to contravene the said order, but allowing his appeal, the Supreme Court has held that the act of carrying paddy did not attempt to criminal attempt, and it was observed in this case that overt act of the appellant is an attempt or as a preparation. So it was considered in this case, and then in this case it says that it is quite possible that the appellants may have been warned that they had no license to carry the paddy, and they may change their mind. So it is necessary that what was the intention, and that intention could be changed at any time, and so is the difference between preparation and the attempt. Now I'll be just forwarding and moving on towards another one of the important topic, that is what is the difference between preparation and attempt, because it is very much necessary to understand that what is preparation and what is attempt, because there are so many controversies and many problems arise as to what constitutes preparation and what constitutes the another stage, that is the attempt. Now this preparation, it consists in devising or arranging the means or the measures for the commission of the offense, that is, and after the preparation ends, the attempt starts. And in the preparation stage, the person still has a time to change his intention, as was also seen in that case, in the Malkiyat Singh case. And in preparation, the person can withdraw from the scene of the offense by changing the intention. Now a preparation is generally not punished, and except under section 122 and 126 and 399, etc. Now if a person, if he poisons with an intention to kill bee, up to this stage he is not punishable, but it is impossible to show in most of the cases that the preparation was directed to a wrongful act, and or was done with the evil intention or the motive. So it this is how the differences are to be understood, that whether the particular act was towards this preparation stage or towards the attempt stage. Now talking about what exactly constitutes the difference between preparation and attempt. Now this attempt, it is a direct movement towards the commission after preparation is made. Attempt begins where the preparation ends. In the attempt stage, the person has no chance, and the person shall be called as accused. And while every attempt to do a criminal act defined in this code is punishable, and if, for example, like A mixes the poison in the blood which B is going to take, it is an attempt to commit the offense of murder, and now in this case A would be punishable. But if he just bought the poison to give or to administer to B in order to kill him, but he had not done that, then at that stage just buying of the poison will not constitute as a attempt. It will just be considered to be at the preparatory stage, and so he will not be punishable in that situation. Now if we talk about attempt, an attempt is made punishable because every attempt, although it fails to achieve the result, it must create alarm, which of itself is an injury, and the moral guilt of the offender is the same as if he had committed or he has succeeded in committing the offense. Now it is submitted that each and every stage is to be taken into account for charging someone as an offender of the criminality, and such person should be criminally liable for such committing that attempt to commit that offense. And it is essential that all the stages are fulfilled and satisfied simultaneously, and if one stage is absent, it will not amount to crime under IPC. So this was all about the preparation and attempt differences, and I have discussed about the attempt and the essentials. I hope it was clear, and thank you for listening.